All right, we're starting our hearing docket for November 29th, 2021. Ms. Ish is going to announce the case name and cause number for the first case on the docket.
We've got Home et al. Versus 5 Star Global et al. Cause number DC 2008643.
Okay, let's have everybody make their announcements. And Tony, we're going to be on the record for this. Ms. Pettit, if you want to make your announcement.
Good morning, Your Honor. Julie Pettit and David Urtiago on behalf of the plaintiffs.
Mr. Tillotson.
Good morning, Your Honor. Jeff Tillotson here on behalf of the 5 Star Global defendants.
Good
Ms.
morning,
Ish.
Your Honor. Ms. Ish and Mr. Ahmed on behalf of Southfield.
Okay, let's go ahead and get started. I've read all the briefing. It was very well done. I have to commend everyone for the briefing on this case. Ms. Ish, whoever did your briefing for you, did an excellent job. No surprise. And anyway, I do have a couple of questions, but I'll let you get started.
Your Honor, may I share screen?
You may. I'll give you 1 second. There you go.
Thank you, Your Honor. Can you see my screen?
Yes.
Okay. So as you know, we are here on our motion to strike Southfield's jury waiver. Your Honor, strike Southfield's jury demand. This is our motion for this to be a bench trial. As Your Honor recalls, earlier this year, you struck the jury demand of the 5 Star Global defendants. And so that will be a bench trial. I believe it's set for February right now. And so at issue today is simply the jury demand with respect to Southfield. The parties, as you're probably aware, the 5 Star Global parties and my clients entered into what we call the APA, the Asset Purchase Agreement. And that particular agreement was between 5 Star Media, the seller, and 5 Star Global, who was the buyer in that agreement. That agreement transferred assets from my client, 5 Star Media, to 5 Star Global entity. And the way that that was done was because of a $10 million loan from Southfield. So basically there's a transaction, assets are transferred, and Southfield is the one that funds that transaction. So this transaction never would have happened but for the fact that Southfield loaned $10 million in connection with
But Ms. Pettit, this lawsuit is not about the loan agreement, right?
I disagree, Your Honor. The lawsuit is about the value of 5 Star Global. And as I'll show on a slide in just a moment, all of this is in connection with, this is all one transaction.
But I guess my point is that you're not suing Southfield because they didn't make the loan.
That's correct.
And Southfield's, are they suing you under the loan agreement? Or are they suing your client?
They have not filed any counterclaims, Your Honor.
Okay.
So Southfield loaned $10 million to 5 Star Global to purchase these assets from my client. My client, Mr. Holm, is the chairman of the board of the newly created entity, 5 Star Global. So as to our claims, we filed a claim against Southfield for breach of fiduciary duty under a number of theories. All of those theories with respect to damages, we are suing for the loss of value that has been caused to 5 Star Global, of which Mr. Holm is suing derivatively, and he is the chairman of the board of 5 Star Global. So the loan agreement, which Your Honor just referenced, is signed by Southfield and by 5 Star Global. There is no dispute that that loan agreement is signed by those two parties, of which Mr. Holm is the chairman of the board and is suing derivatively. The standard, which I'll just cover briefly from the Bank of America case, is that a conspicuous waiver provision in a contract is prima facie evidence of a knowing and voluntary waiver and shifts the burden to the opposing party. There's 4 waivers here, Your Honor, and we can talk about the last 3, but I think the analysis ends with the loan agreement, which is signed by Southfield. That is undisputed. It's signed by Southfield and it's signed by 5 Star Global, of which Mr. Holm is the chairman of the board.
Let's talk about the other 3.
Yes.
Southfield didn't sign any of the other 3.
That's correct.
Okay.
That is correct. On the loan agreement signed by Southfield, I think it's important to note in this section, this doesn't say the parties or have any limiting language. Your Honor, this is a broad jury waiver. It says to the fullest extent permitted by applicable law. This doesn't say just the parties or anything of that nature, but to the fullest extent permitted by applicable law, each obligor waives the right to trial by jury. And any proceeding, claim, or counterclaim of any kind relating in any way to the loan documents, the obligations, or the collateral. The collateral, as I'll show you what the definition of that is, it's the entire business. It is Five Star Global. It is all assets, all intellectual property, every single thing that you can think of in connection with Five Star Global is contained in this definition of the collateral. So there is no limiting language. This is supposed to be to the fullest extent permitted by applicable law. Southfield signed this. Five Star Global signed this. Both are parties to this agreement. Mr. Holm is suing derivatively in connection with the obligations and the collateral. Our entire damage model is that the collateral has been damaged to the tune of $10 million. That is our damage model. As I mentioned, this is all one transaction. This is on the first page of the loan agreement, Your Honor. So the very first page, there are two recitals, and both of them are pointing back to the APA. So the very first recital, borrower, seller identified therein, and member identified therein have entered into an asset purchase and contribution agreement. That is the APA that everyone is fighting about. That is the one of two recitals in the loan agreement itself. The second recital, borrower has requested the lenders to extend credit in the form of loans on the closing date in an aggregate principal amount not in excess of $10 million. So again, all of this is about the APA, which never would have happened on May 18th. And again, that's when all of the documents in connection with this transaction were all signed on May 18th, 2018. It was all one big deal. When you go to section 2.1.3 of the loan agreement, it says this: the proceeds of loan shall be used by borrower solely to finance the acquisition transactions, which is the APA and everything that transferred these assets. So it's clear just on the face of all of these documents that they're all interrelated and that it's all one transaction. So in this analysis, Your Honor, when Southfield is a party to the actual jury waiver, we don't get into the direct benefits estoppel analysis. That does not come into play because they are a signatory to a contract with a very, very broad jury waiver. Here, we've cited, Your Honor, to a number of cases where Mr. Holm can enforce the jury waiver in the loan agreement. I think Southfield's response in many ways conflates the two. And so I want to make sure that we are keeping them very separate, that we don't get into any sort of direct benefits estoppel analysis here. Here, they signed it. And so the quality lease and rental holdings case says the waiver extends to non-signatories that seek to invoke the waiver as agents of the corporation. That is not controversial. That is what happened here. Mr. Holm, as chairman of the board.
Ms. Ish, how do you distinguish this NRA Credit Suisse First Boston Mortgage Capital case?
Your Honor?
Yes.
It's actually a very simple distinction. NRA Credit Suisse derives from a line of cases that stand for one proposition and one narrow proposition. When you read the case, you realize that they stand for this. When a plaintiff that is a signatory to a contract sues a non-party to the contract, and that non-party is an agent of a party to the contract, the agent gets to rely on a jury trial waiver or an arbitration agreement that is within the contract of the party. So this is not a situation where we've got Southfield suing Ms. Pettit's clients, plaintiffs in this case, and trying to avoid the jury trial waiver in the Southfield loan agreement. That's not the proposition, or that's not the circumstances of this case. And that's the only way that Credit Suisse and Quality Lease and these other cases that plaintiffs cite to with regard to the agency principle, that's the only way they could apply. It's number one, Your Honor. Number two, if you read Credit Suisse, if it even could possibly be applicable here, the Credit Suisse also makes very clear that you've got to have a heck of a lot more than just an allegation that Mr. Holmes acting as the agent of FSG and or FSG Global. If I could share my screen real quick, I could help show you some call outs from that case that will make it very clear that plaintiff has not met its burden of showing.
Ms. Pettit, go ahead and let her share screen.
Sure. Let me see how I do that. Okay. I think that's done.
Here we go. And I think I've got mine now. Here we go. Are you guys seeing my screen?
Yes.
Are you seeing the right screen? Yes. Okay. All right. So what else did Credit Suisse say? Credit Suisse said, just throwing out some allegation that a party is acting as an agent of a signatory to the contract simply is not enough. Just saying, hey, Home was acting as the agent of FSG or FSG Global isn't enough. You have to actually produce evidence that Home indeed was. And Home cannot do that here. And the reason why he cannot do it here is because there's an actual operating agreement that is applicable to these parties, to FSG and FSG Global. And that operating agreement specifically states when a board member could possibly be acting as an agent of FSG or FSG Global. Here, under management, it specifically provides that all actions or decisions of the board shall be made by and shall require the affirmative vote of a majority of the members of the board. Home might be a board member right now, but he himself cannot simply say, hey, I'm acting as an agent, and without having an affirmative vote of a majority of the board. And we certainly do not have a situation, Your Honor, where a majority of the board did vote that Home could act as the company's agent. That just didn't happen. So the fact that he's a member of the board does not mean he's an agent. Number two, we could also have an agency situation on behalf of 5-Star Global or 5-Star Global Holdings if Home was an officer of FSG or FSG Holdings, but he's not. He is not an officer of FSG or FSG Holdings, so he is not acting as an agent in attempting to invoke the loan agreement's jury trial waiver. And there's no other evidence that Home is actually acting as an agent in trying to parachute into agreement he's not a part of and pick out this jury trial waiver.
Ms. Pettit, what is your response to that?
Your Honor, it's undisputed that Mr. Holm is the chairman of the board. And when you look at the petition on its face, it's clear that he is suing for the damages that Southfield directly caused to 5-Star Global. I think the Credit Suisse case is interesting because it's later impacted by the Bank of America case, which was briefed and we can talk about. But again, that is the purpose of a derivative suit. 5-Star Global isn't suing Southfield. That's the whole purpose and why we had to bring this as a derivative suit. I think it's undisputed, Your Honor, if 5-Star Global, and I think this is an important distinction, if 5-Star Global had sued Southfield, there's no argument at that point. It's 100% clear. Both are signatories to the contract. There is a jury waiver in place. But 5-Star Global hasn't filed that suit and is refusing to do so. And so Mr. Holm has done that derivatively. This isn't some far-fetched argument. 5-Star Global and Southfield have signed a jury waiver that is conspicuous. And I don't think there's anyone that is disputing that.
Your Honor, we are not disputing that in the loan agreement that has nothing to do with any claims in this case, there is a jury trial waiver. But plaintiff's argument that but for the loan agreement, this deal would have never happened has specifically been rejected by the Supreme Court of Texas. This but for argument just simply doesn't exist. And sorry, there's a bunch of cases that are floating around. So if you could give me a second. Here we go.
And Your Honor, just so we're clear, I had a couple more things to say in my argument. I hadn't, unless Your Honor has cut me off. I was.
If you could just
not
let me,
done.
just real quick on the but for part here. Even if the claim refers to or relates to the contract or would not have arisen but for the contract's existence, this idea of direct benefits estoppel, it's just not implicated. So tying everything to, or arguing that none of this dispute would have happened without the loan agreement simply isn't enough to take away Southfield's constitutional right to a jury trial when plaintiffs aren't even a party to the one agreement that Southfield signed with a jury trial waiver, and plaintiffs aren't suing us for anything tied to that agreement.
Your Honor, Ms. East just did what I accused her briefing of doing. She's arguing direct benefits estoppel. We don't get there with respect to loan agreement. That never comes up. Those cases aren't relevant. Southfield signed a jury waiver. So everything that she just argued is exactly not our argument. We don't get there unless we're looking at the other three waivers.
Was Mr. Hume can you guys hear me okay?
Yes, Your Honor.
Okay. Is he acting as an agent for the corporation then, right?
That is the question under the loan agreement. Yes, Your Honor.
And
But whether direct benefits estoppel applies, that's not the argument here because Southfield is a signatory.
And Ms. Ish, what is your argument that he's not acting as an agent because he doesn't have authority?
Right. Number one, he has no authority. I just showed you the contractual provisions that say he does not have the authority to act as an agent on behalf of FSG or FSG Global. And Ms. Pettit hasn't cited to any facts that would, state that he was. I think that's even more important, right? I mean, it's not, you've got a contractual provision that says you can act as an agent on behalf of these signatories to the loan agreement if you do X or Y. And neither of those are applicable here. And there's simply no other evidence that Home was acting as an agent or is in right now. Home right now is acting as an agent of FSG in seeking to enforce.
And Ms. Pettit, your argument is that he's bringing a derivative claim.
Yeah, he's got a derivative claim, which he's allowed to do as an investor and owner, chairman of the board. He's allowed to do that. And that's what he's done.
And I would like to jump in there. Ms. Pettit brought this, only asserted the derivative claims, I think within the past 3 weeks, and it was after she did the briefing on this motion. So we haven't even, there's a big question of whether those derivative claims are even, they're even valid. And she didn't even argue that she was bringing this derivatively originally. So this might take a little bit more briefing, Your Honor, and it also might take us going through a motion to strike the derivative claims from the.
Ms. Ish, that's exactly kind of what I was thinking. You kind of reached into my brain there because I was thinking that exact thing. Is it true, Ms. Pettit, you just brought these claims?
No, Your Honor, the claims have been on file since the beginning of the case. I believe since 2020, the claims against Southfield have been
the derivative nature has just been brought.
Sure. So the reason why we did that, we have not changed our claim. This claim has been here. We don't believe that we technically have to file it we don't have to plead it as a derivative claim. We believe that that's clear, but based on what happened in the Delgado trial, because that issue was called into question at trial, after the Delgado trial, we decided, let's go ahead and put it in there. We don't think we have to, but we went ahead and just in an abundance of caution pled that so that it wouldn't be an issue in this case, but the claim hasn't changed. It's clear. I mean, if we weren't bringing it if we weren't bringing it derivatively, we wouldn't be able to claim damages based on the decrease in value of Five Star Global. So,
but when did you first plead that you were bringing it derivatively?
Again, I would argue that we had done that since the beginning and that it wasn't necessary, but the date of our most recent petition, give me one moment, was November 1st.
Are there any cases out there that talk about whether or not somebody who's bringing a claim derivatively can rely on a jury waiver and arbitration clause?
Not that we have seen where it specifically calls someone out for bringing it in a derivative nature. I don't think either of us found that, or we certainly would have brought it to Your Honor. So
even under an arbitration claim? Has there been anything even, because it's not exact, I know the law's not exactly the same, but there is some overlap.
Not that, actually, I'm going to defer to Mr. Urtiago because he may know if there's one in the arbitration context. I haven't read one, but if there is one, he would, he would
Mr.
know about it.
Urtiago?
Yeah, typically the direct benefit estoppel argument is normally what's applied for non-signatories in terms of the specific question, whether or not someone is acting in an agency capacity when they're bringing a derivative lawsuit, thus triggering the argument that we were talking about. I'm just not sure. I have not specifically briefed out that issue. So I'm unaware that there may exist some case law on that. I just don't know it.
And I'll tell you from Southfield's position, Your Honor, we have not, given that it wasn't argued in the original motion, we have not done our deep dive on that. So I'm hopeful we could find something that's directly on point.
Ms. Ish, my suggestion at this point, and I kind of want to talk a bigger issue after we discuss this, is that I think your inclination is correct, is that we should go ahead and wait, give you a chance to try to file a motion to strike or whatever the appropriate motion is on the derivative claims. And then, because I tend to agree with you that if he's not acting as an agent for the corporation, then probably that the jury waiver, that the jury trial demand should not be struck. But I think you need to have an opportunity to bring that claim and kind of brief that out. One question I kind of have here, though, just as a big picture, and I want to get Mr. Tillotson's thoughts on this, is that let's say I do strike the jury demand, sorry, I do allow the jury demand to go forward. Are we going to try this? Can you try these cases separately? How would we do that exactly? Because they seem very intertwined.
I would say that from our position, yes, these are discrete actions or inactions that Southfield did or did not take. And they don't really require reference to plaintiffs' extensive and different claims against the five-star entities.
Mr. Tillotson?
Well, you can certainly try a jury, non-jury case. Yeah, you have a jury there, and what controls is just the verdict form that they get. So they truly.
You mean try them together? One of them
Yeah.
I would decide, and the other one the jury would decide.
Correct, Your Honor. It would be no different than if you tried a case against us and some were jury and some were equitable claims. Your Honor would submit the verdict form just to the jury and you would decide the equitable claims. I haven't really thought much about whether there's some efficiency to trying these separately, but in terms of can you have a jury and non-jury, of course, the jury just decides whatever you tell them to decide on the verdict.
And on Southfield,
And I'm sorry, just one last thing, and I didn't mean to interrupt. That is subject to Southfield or the plaintiff saying, I'm going to be prejudiced by some evidence in this case, or my trial should only last one day, but Tillotson's poor trial has to last 2 weeks. And so I'm not meaning to jump in on you and make you part of my party here, but practically speaking, you certainly could do jury and non-jury, Your Honor.
Okay. Nothing needs to be decided on that today. Ms. East, do you want the opportunity to file that motion to strike and get that teed up before we decide the jury trial issue?
yeah, so I would definitely like the opportunity to look at their derivative claims a little bit more closely. And perhaps instead, it might not even be a motion to strike. Perhaps it is a supplemental response to Ms. Pettit's motion to strike our jury demand that explains why her or the plaintiffs bringing this case derivatively doesn't change the fact that they don't get the right to the loan agreements jury waiver. It could be either. Even if we don't move to strike the derivative claims, I think there could be case law out there that would help us to establish why the jury waiver in the loan agreement.
Bottom line is you're passing the hearing for today.
Well, it was my hearing, Your Honor.
Okay. Bottom line is I'm passing the hearing today.
I think we need a little bit more briefing on the derivative aspects now that plaintiffs have added this.
Your Honor, the only thing I would add also is I know we've spoken mostly about the loan agreement language, which the line of cases indicates this agency issue. The other The other three waivers, obviously the agency issue doesn't come in. It's the direct benefits estoppel analysis. And that one, I think Ms. East would have to concede, as would I, that there is not a case directly on point one way or the other with respect to this exact issue. The 14th Court of Appeals originally would have ruled in Ms. Isha's favor on this issue back in 2008. Then the Bank of America case from the Texas Supreme Court happened in 2009. And then the 14th court undid what they had done originally in 2008. And I don't think either side has found, with respect to those other three waivers, a case that definitively points one way or the other. So I think that would be a new issue for Your Honor to decide. But certainly we would like at a later date the opportunity to argue that particular issue in front of Your Honor as well.
I just didn't find that very persuasive, and I don't really want to blaze new law on this. So I'm not a huge fan of jury trial waivers anyway. And so if I'll follow the law if I have to, obviously, but I'm not going to make new law to try to expand jury trial waivers. And so I think let's just kind of stick with this issue and whether or not the loan agreement is something that binds Ms. Isha's client. So, but go ahead and do Ms. Ish. You need to confer with Ms. Pettit and just figure out, are you going to do this? Are you going to file a motion to strike the derivative claims or not? And if you're not, then you both need to brief this derivative issue and then reset this, but you need to let her know. It's only fair to let her know fairly quickly on that issue. So do you want me to put you guys into a breakout room, or do you want to talk some other time?
I can give Julie a call, I think. Would you be okay with that, Julie?
That's fine with me.
Okay.
You guys have a great day.
Thank
All
you, Your
right.
Honor.
Thanks again for your compliment, Your Honor. I know my associate that helped me is on the phone or on the Zoom.
Who's that?
Will Fox. He did a fabulous job with this briefing.
Mr. Fox, we can't see you, but you did a good job. That was very well briefed. I thought I'm surprised it's a young associate that did that, because that was very well done. So
Thank you.
I don't know if you can hear me or not, but good job.
I can. Thank you very much, Your Honor. I appreciate hearing that.
All right. You guys have a great rest of your day, okay?
Me too.
Yeah.
Bye.
Our next hearing is on, I'm sorry, there's a couple people that are maybe here on the dismissal docket. Mr. Hilby, I think you were here on the dismissal docket.
Yes, Your Honor.
So your opposing counsel basically said that he's been trying to get payment instructions on your case, and you haven't been responsive. And so we've tentatively DWOP'd the case, but what's going on? What are you not responding to him?
We've reached out to him, but the issue here, Judge, is that we've got a $50,000 insurance policy and a $115,000 claim by FICA. So we're trying to negotiate that subrogation interest down. They've asked for us to get them the instructions. They know about the FICA lien. They know we're negotiating it. They've asked us to get the final lien amount so that way we can get them those drafting instructions. So we've been in contact with FICA. I think that we had sent them a follow-up email, I believe, late last month. And so we're trying to get that finalized so that way we can get this thing out of your
what is the cause number on your case?
Cause number is DC 20-18957.
Let me find that. All right, sorry, I can't find it this quickly. So DC 20, what is it?
18957.
All right, we'll give you 30 days on that if you could let defense counsel know. Just in the future, make sure you show up to these DWOP hearings, because this case could have been dismissed.
Yes, Your Honor. I appreciate y'all holding it open for us.
All right, Rhonda, go ahead and extend that one 30 days. Okay. Anyone else here on the dismissal docket before we move on to our hearings?
I am, Your Honor. I'm here on Stephen Frank versus Alicia Alexander, DC 20-13-357.
DC 13357. Okay. What's
Yes,
going
Your
on with this one?
The case is settled. We're just wrapping up a lien issue, hospital lien. We've
We've
pretty
already
much-
extended this one 30 days. The
Okay.
opposing counsel showed up and got you an
I'm
extension.
I'm sorry I was late. Sorry,
It's
Judge.
okay.
All
Have
right.
a great rest of your
Thank
day. Anyone
You
else
as
here on
well.
the dismissal docket? Okay. Our next case is a special appearance in the Haylett versus Inception Sports case. But also I believe we have a motion for disqualification in that case as well.